Okay, I think we'll get going. Welcome everyone to Gowling WLG and our Spring Construction Law Forum. My name is Ted Betts. I'm the head of our Infrastructure and Construction Industry Sector Group, and we are really excited about having you here today, at least virtually, and looking forward to sharing some information, law, and some good discussion on legal issues and commercial issues affecting our practice area in our industry. This year marks the 10th year that we have at Gowling's been running our forum. We have a spring construction law forum and a fall construction law forum. These are designed to help the industry stay informed of changes in the law, as well as changes and trends in the industry. Historically, we have held our meetings in person, but due to the pandemic in 2020, we held our first national online virtual forum. And that was such a big hit because we were able to have people join us from across the country, and including our own lawyers from across the country. So we are going to continue that, but in the fall, you'll see, hopefully you can join us in the fall as well, because we're going to have some special events to celebrate 10 years of running these forums. They're going to be a hybrid in-person with special events in each of our offices. So look out for that in the fall. We do have an exciting program today, and it's jam-packed, so I do want to get to it. We are going to do our usual start on updates on law. So what we have done in the past and will continue today is a refresh on some of the more recent legislative changes from our speaker out in Calgary, Maria Serrano. And then Tristan Neal in our Kitchener-Waterloo office is going to give us a few key case law updates. And then we'll move into our program, a panel discussion on supply chain challenges and trends, which has affected all of us. So before we get into the program, I'd like to start our program with a land acknowledgement. We are all across the country on this webinar, but here myself, I'm in Toronto, and so I'll speak from the City of Toronto's perspective, but we are cognizant and recognize and acknowledge, make land acknowledgements across the country. For Toronto, the City of Toronto acknowledges that we are on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. The city also acknowledges that Toronto is covered by Treaty 13, signed with the Mississaugas of the Credit, and the Williams Treaties signed with multiple Mississaugas and Chippewa bands. Thank you for joining us, and I hope you enjoy and get a lot of information out of our session today. And with that, I will pass it over to Maria.
Good morning, everyone. I'm Maria Serrano, out of the Calgary office, and I'll start with a brief update on prompt payment legislation across Canada. Prompt payment and mandatory adjudication legislation is being enacted across Canada in an effort to lessen perceived payment delays on the construction pyramid. I'll provide a brief overview of the developments in each jurisdiction. To start off, we'll start off with Ontario. The changes to the Construction Act, so formerly the Construction Lien Act, introducing prompt payment and adjudication, came into force on October 1st, 2019. It introduced strict payment deadlines. Briefly, it required an owner to either pay within 28 calendar days or dispute the invoice within 14 calendar days. And then in-turn contractors must also pay their subcontractors within a stipulated amount of days or send notices of dispute. The changes also introduced adjudication, so a quick and binding method of resolving disputes in construction projects. And this adjudication regime in Ontario was being administered by the Ontario Dispute Adjudication for Construction Contracts, so ODAC. During the 2022 fiscal year, ODAC reported 121 adjudications were commenced and 67 determinations were rendered. So 34 remained open and the others that are unaccounted for were terminated on the consent of parties, primarily because they settled their dispute. In British Columbia, as of right now, British Columbia still does not have prompt payment legislation. However, it's expected that it will undertake consultation with the construction industry regarding potential draft legislation in 2023. So at least we know something is in the works. In Alberta, as of last year, August 29th, 2022, the Prompt Payment and Construction Lien Act came into force. This amendment introduced prompt payment, also an adjudication framework for the payment disputes, and an extension of the lien registration periods. So this would apply to contracts entered after August 29th, 2022. For contracts that were entered into prior of August 29th, 2022, and scheduled to remain in effect for longer than 2 years past that date, what were then given until 2024 to amend their terms to comply with the new provisions of the Act. In Alberta, Arcana was the designated nominating authority under the Act, and this means that they'll have the power to nominate adjudicators to resolve disputes. And it's so far there's been about 5 matters referred to adjudication. In Saskatchewan, the new prompt payment legislation came into force on March 1st, 2022. So it's also quite recent. It describes prompt payment and adjudication regime that largely parallels Ontario's. And it only affects contracts entered into on or after that March 1st, 2022 date. The Saskatchewan Construction Dispute Resolution Office will act as the official adjudication authority. So it will provide adjudicators. Now for Manitoba, actually very recently, on May 30th, 2023, Bill 38 received royal assent. This is significant because 3 previous attempts to legislate prompt payment had been unsuccessful. The aim of Bill 38 is to establish a prompt payment scheme as well, which will hopefully facilitate that timely flow of payments on a construction project. It'll also introduce an adjudication process for disputes arising out of the prompt payment scheme. However, many of the details remain to be set out in further regulations of the Act. Now for Quebec, Bill 12 received royal assent on June 2nd, 2022. It amended the Act respecting contracting public bodies to provide a foundation for prompt payment legislation, which may ultimately be similar to that enforced in other parts of the country. And so it's anticipated that the regulations will include timelines setting out payment dates and a fast-track dispute resolution process. However, much of the prompt payment and dispute resolution scheme remains to be clarified by the regulation. Now for the Maritimes. So in Nova Scotia, the Builders Lien Act received royal assent on April 12th of 2019, but it has not yet come into force. Once it comes into force, the legislation will be renamed the Builders Lien and Prompt Payment Act, but the regulations are still being developed to establish the timelines and the adjudication scheme. So once ready, we'll be a step closer to it coming into effect. For New Brunswick, it really recently on June 16, 2023, the Construction Prompt Payment and Adjudication Act received royal assent, but it's not yet come into force. It will also establish mandatory prompt payment and adjudication for the construction projects, but a lot of it will be set out in the regulations that have yet to be introduced. Princess Edward Island and Newfoundland do not appear to have any plans to develop a prompt payment scheme as of yet. So we'll have to keep waiting on those. Now, lastly, it's the federal legislation. The Federal Prompt Payment and Construction Work Act addresses the non-payment of contractors and subcontractors performing construction work for federal construction projects. This was passed on June 21st, 2019, but it is not yet in effect. The difference with the federal legislation is that there will be no grandfathering of existing contracts. So there will be a 1-year deferral period, which will likely be disruptive to certain contracts. So it's good to keep in mind. And with that, that's the end of my portion, and I'll turn it over to Tristan for some case law updates.
Okay, thank you. My name's Tristan Neal, and I work out of Gowling WLG's Waterloo Region office, and I'm going to share my screen now and provide an update on some recent cases in the construction law area, mostly coming out within the last 6 months that we think are noteworthy and certainly worth a read through if you're so inclined. There's much more material in the slides than I can cover in the next 20 minutes, and so I will go through them quite quickly, but I understand that a copy of the slides will be available to you if you want to take a look in greater detail. I'm going to start out with 2 cases from Ontario that are dealing with adjudication. So it's a good follow-up on the legislative updates, because as many of you are now familiar with, the adjudication regime is a fairly new introduction on Ontario. And it's only now that we're really starting to see an uptick in the number of adjudications taking place and starting to see a few adjudication related decisions trickling out of the courts. And I think this is of interest in Ontario and of broader interest to other provinces that are either implementing their own adjudication systems or that are considering doing so in the future. So to start off, I'm going to discuss the Anatolia Tile and Stone decision from Ontario's Superior Divisional Court. And this case deals with leave to appeal to the Divisional Court of an adjudicator's decision. And it's important to remember that an adjudicator's award is temporarily binding, but ultimately provisional. It's provisional in the sense that parties, if they don't like the award, can continue to litigate their dispute and attempt to obtain a different outcome from the court or from an arbitrator. And so the Construction Act in Ontario does not allow for an appeal of an adjudicator's decision. Instead, it allows for a judicial review from the divisional court with leave or permission of the divisional court. And in this case, a party requested a judicial review and that request was denied. The court set out and reminded us of the test for a request for a judicial review of an adjudicator's decision, and reminded us that typically that's going to be granted if there's been some procedural unfairness at the level of the adjudicator, but reminded us, and this is something that's very important for parties considering a request for leave, reminded us that the system of adjudication is to be faster, more streamlined, more efficient, less costly than going to court. And so the court is not expecting to see the level of procedural safeguards that you would normally see in the regular court process. So certainly if you're thinking of making a request for judicial review based on procedural unfairness, just remember that the standard in the adjudication context is going to be different than the standard in other contexts, such as administrative tribunals or the court system itself. And there's a 2-part test for leave, and you can check off one of 2 boxes at each stage of the test. So at the first stage, really, you need to show the court that there's likely something wrong with the adjudicator's decision, that either there's good reason to doubt that the decision was reasonable, or there's good reason to believe that there was a procedural unfairness that likely affected the outcome. If you check off one of those boxes, you can move to the second stage of the test, And at that stage of the test, you really need to convince the court that there's some sort of lasting or important impact of the issue that you identified at the first stage of the test. So either there has to be some lasting prejudice effectively from the unreasonableness or the unfairness that can't be remedied, or that likely can't be remedied by continuing to litigate, or there has to be some important issue that transcends the dispute between the parties and that is of broader importance to the legal community, such that the divisional court should weigh in and address that issue. So really very similar test in a lot of ways to other tests for leave at the divisional court, such as a request for leave to appeal an interlocutory decision. The court mentioned a number of points about the effect of not paying an adjudicator's award and then requesting leave for a judicial review. You can look through these in greater detail, but the upshot is that if you don't pay the award, it may be more difficult for you to get a successful request for leave to judicially review that decision. Moving on to the Oaken construction case, a recent decision of Ontario's Superior Court also dealing with adjudications. This case addresses a concern that an owner had when it was ordered to pay $200,000 to a contractor by an adjudicator with respect to a contractor's lien, when the owner also faced a lien from one of that contractor's subcontractors. And of course, in the typical situation, you have Section 24 of the Construction Act in Ontario saying that you need to maintain your notice holdback. When you become aware of a lien, you are to retain holdback essentially to cover that lien. And this owner said, well, I have this order to pay out money to the contractor. Without this order, I normally would have retained that money as notice holdback for the subcontractor's lien. And I'm a little bit concerned about paying out this adjudicator's award because I may then be at jeopardy under the fairly strict provisions of the Construction Act for allowing payments of holdback. And so the contractor said, or rather the owner said, I'm going to put this award in a trust account and I'm going to ask the court what to do. And so the owner went and sought directions on how to deal with this situation. And the court made the following determinations. The court said that adjudicators' awards need to be paid unless there is a stay in place. And the reason for that is that adjudication is part of the prompt payment regime that is supposed to address disputes more quickly and keep funds flowing more quickly. And so if we created a situation where even in situations where there isn't a stay, we allowed owners to withhold payment, then that would to some degree defeat the purposes of the prompt payment regime. And so these awards do need to be paid despite Section 24 of the Construction Act. And the court said that the Construction Act's trust provisions effectively protect the owner in this situation, because even though the owner is making a payment to the contractor is to act as a trustee for the subcontractor's interest in those monies. Next, I'm moving to Alberta and the Alberta Court of King's Bench decision in Canadian Pressure and Testing Technologies. This is a decision dealing with pay when paid provisions, and it's Unfortunately, it's coming out a little bit ahead of the new legislation in Alberta dealing with prompt payment. I think we're expecting to see some cases both in Ontario and Alberta and the other provinces that put prompt payment legislation in place that will deal with pay when paid clauses. But this is a case that doesn't deal with that. It's strictly dealing with drafting points for prompt payment clauses and how they differ from what the court is calling pay no later than clauses. This is the clause that was at issue in this case, and it fairly clearly states that the contractor will pay what is due and owing to the subcontractor no later than 5 business days after receiving payment from the owner. And the contractor is saying, look, this is a pay when paid clause. I don't need to pay the subcontractor until I get payment from the owner. And the subcontractor is saying, no, this isn't a true pay when paid clause. And this is what the this is what the court had to say. The court said that if you want a true pay when paid clause, you have to be very, very clear that you are restricting the subcontractor's right to payment. If you want to restrict that right to payment, you have to be very specific. You have to explicitly state this, and you need to clearly say under what circumstances that right to payment will be restricted. The court said that it's not going to infer a pay when paid clause from other language that's dealing simply with the timing of payment. So the idea in the clause that we were just looking at, that payment is going to come no later than 5 days after payment is received, simply is setting up a timeline for payment, and it is not going far enough to be a true pay when paid clause. So certainly something to keep in mind when drafting these kinds of provisions, and of course keeping in mind how such provisions may be impacted by the prompt payment legislation that may be in force in your jurisdiction. Next, I'm heading back to Ontario with a recent decision from the Superior Court in Ontario in XPL Construction Solutions. And this case deals with Section 47 of Ontario's Construction Act, which gives the court the power to discharge a lien. So that's a very significant remedy if the lien is frivolous, vexatious, or an abusive process. And in this case, the owner made perhaps a slightly different argument. Didn't argue that the lien was an abusive process and so it should be discharged, but made a similar argument that there had been an abusive process and that grounds a discharge of the lien. The court did not agree with the owner in this case, and that was because of the specific facts as to what was characterized as the abusive process. Here, the owner had obtained an undertaking on a cross-examination from the lien claimant, and had also obtained a court order that undertaking should be answered. The lien claimant failed to comply with that court order and didn't answer the undertaking. And so we have something that's significant. It's a court order that hasn't been complied with. But the court said in this case, yes, failure to comply with a court order may be an abusive process, and it may be an abusive process that justifies the discharge of a lien under Section 47, but not in this case, not a failure to answer an undertaking. And so the key takeaway here is that when the court is considering what remedy to grant under Section 47, of Ontario's Construction Act, it's going to undertake a proportionality analysis. The court wants to make sure that that very significant remedy of discharging the lien is proportionate to the wrong that has been committed. And in this case, really the court said that this failure to answer an undertaking, even though it was ordered to be answered by the court, simply wasn't serious enough to warrant a discharge of the lien. The next case deals with limitation periods and the discoverability of causes of action such that a limitation period starts to run. And typically you have 2 years under Ontario's Limitations Act and most Limitations Acts across the country to bring a claim in court from the day that you either discovered or should have reasonably discovered the claim. In this case, the Region of Peel hired a contractor to install guardrails on the roofs of a number of buildings, and that work was completed in January of 2015. Around the time of completion of the work, the Region of Peel discovered that the building roofs were leaking. But it wasn't until March 13th of 2015 that the Region of Peel obtained evidence from its consultant, or a determination from its consultant, that the leaky roofs had been caused by damage sustained during the construction. So that was when the region said it knew, or reasonably ought to have known, that the contractor was responsible for the leaks. And so it was within 2 years of that date that the region brought its claim. The contractor argued that the claim was discoverable much earlier, a few months earlier, such that the claim was statute barred. And the contractor said that the region knew when the work was ongoing that this was a risk, that this damage was a risk of the work that was being undertaken, and that the region knew about the leaks in 2015. In this case, the court sided with the Region of Peel and found that it wasn't until the region had its consultant's report that it had the key facts that were necessary to know that there was a cause of action or a claim against the contractor. And before that point, it was only speculation that it was the contractor that had caused the leaks. And so I think this case is an interesting case. It's not a case setting out an important new principle, but it is a case that can be handy and one to keep in your back pocket in case you need to mount a similar argument to the one that was raised by the Region of Peel in this case. Finally, and briefly, we've had a very recent decision from Ontario's Divisional Court in Devlin Construction Limited. This case is somewhat notorious in that it deals with the tricky question of whether under Ontario's current legislation we can join construction lien claims with construction trust claims, and the Superior Court in Ontario released some conflicting decisions on this point. So very briefly, under the old legislation in Ontario, this was not possible. It was expressly prohibited. Under the new legislation, it was not expressly prohibited, it wasn't, or expressly permitted. And so we have seen conflicting decisions on this point from the Superior Court, and those have now been addressed by the Divisional Court. And the Divisional Court has said, no, you cannot join lien claims and trust claims. The court based this decision on some statutory interpretation, but I think mainly really based its decision on a policy concern that lien claims are to be summary in nature, that they are to proceed through the system as expeditiously as possible, that trust claims are, at least according to the Divisional Court, more complicated than lien claims. They take longer to resolve, and so there is a good policy reason for keeping them separate. And the hope is that we will be able to push the lien claims through the system more quickly and than we would if they were joined with the trust claims. And so that concludes my update on recent cases. Certainly there has been lots of activity from the courts across the country in the last few months. And now I'd like to hand it over to Jordan Crone, who's leading a panel discussion.
Thanks so much, Tristan. I appreciate your updates. And I'd like to welcome everybody and say hello from Calgary. I'm going to be moderating today's panel, which is on supply chain challenges and trends. And we've got an excellent panel here to cover a number of topics. As part of that, we do have the Q&A function open. So if anyone has any questions, any comments, anything they want to add, please throw it in the Q&A. I'm going to be monitoring it throughout the panel's discussions. I'll, of course, be asking the panel some questions. But if you have something specific that you want to ask the panel, feel free, don't be shy. I will make sure it gets asked or we'll trim it down as appropriate. So let's start with who we have and a couple of introductions on our panel. So myself, my name is Jordan Crone. I'm going to be the moderator today. I'm a partner here in our Calgary office. We have Sahil Shore. He's a litigation and dispute partner based out of Gowling's Waterloo region office. His practice is focused on construction and infrastructure projects, expropriation law, land use planning, and real estate disputes. Sahil was recognized this year by the Legal 500 as the next generation partner in dispute resolution Ontario. We also have Mert. He is an insurance broker and advisor specializing in sectors with complex risk profiles. His background includes construction, real estate and development, retail, metals, mining, and other industrial risks. Mert has over 24 years of experience in the insurance industry and has worked with several global insurance brokerages. He is a partner with Perbs Redmond Limited, an independent Canadian brokerage firm focusing on challenging risks and hazardous industries around the world. And last but certainly not least, we have Kimberly. She is the Vice President of Development Construction at RioCan REIT, one of Canada's largest real estate investment trusts. With over 25 years of experience, Kim plays a vital role in shaping the future of RioCan's mixed-use real estate portfolio and continues to drive the company's commitment to excellence in construction and development practice. She's currently working on The Well, which is Canada's most ambitious mixed-use community development project, and it is an extremely large and complex development piece which gives her some invaluable insights into supply chain management, project procurement, and multi-phase scheduling to align the projects and its priorities. So with that, why don't we start with a bit of an opening question or an opening salvo that I think is important. So Kimberly, did you want to start with sort of what is the current state of supply chain in 2023? What are you experiencing and what are you noticing given your sort of what's happening with The Well and what you're working on?
Sure. Thanks for the introduction there, Jordan. I would say generally, and I want to be very cautious in saying this, we are getting better, or we're either getting better, or what we're experiencing in the past couple of years, in some cases we're catching up, and in others we're just settling into the new norm. But I do think that this is potentially a bit of a false sense of security. We're balancing what was a previous surge in construction while accounting for not only rising costs in material and material delays, but labor shortages in the industry. Now cue in an economic downturn, which has put a bit of a damper on some projects. So we're not really seeing the reality of what should be a post-COVID or post-pandemic supply chain in operation. So I would say this is giving the industry a bit of time to catch up and potentially recreate some of our procurement and supply chain solutions. But I think we also need to be ready for when the market does turn and this comes back to us, what it could potentially look like.
How about you, Mert? What are you viewing the current state of supply chains here in 2023?
Yeah, it's for our perspective, which is the insurance perspective. The big things that kind of worry us and our clients are the lead times for key pieces of equipment or building materials. I was just looking at some statistics, like some of the lead times are up like 600, 700, 800% for some key materials, which is really putting pressure on our clients who are owners and builders. And from an insurance perspective, I was also just looking at the claims in construction and property in general from a claims perspective. And it's just the back in the day, in the 70s and 80s, most of these claims, a lot of these claims were man-made or accidents and fires. Now the percentage are weather events, like all the claims are weather events. And then there's this little piece on top that's the man-made claims for the year around the world. So weather, and we're dealing with all these crazy wildfires in Canada, but just weather related events, which are totally out of our control, directly in the short term are out of our control, are driving huge increases in losses, which are impacting, from an insurance perspective, going to impact construction projects and owners and builders.
Thanks so much, Merton. How about you, Sahil? What are you sort of seeing from your client's perspective, or what are your clients coming to you with respect to supply chains and how they're being affected?
Oh, thank you, Jordan. And just, I echo what both Kim and Mert has said so far in terms of the issues that their respective teams and they themselves are encountering. But I think one of the other bigger issues is what both Kim and Mert briefly touched upon, and that is the nexus between the economy and the issues that we're going to be faced with. Over the course of last few months / a year or two, we've had COVID-19, and we've seen the impact of COVID-19. We've dealt with those claims. The claims, if they're not dealt with, there have been issues surrounding the entitlement under the contract. As Mert mentions, we have efforts to battle climate change, which are on the rise. There's more and an increasing use of prefabricated and modular construction, which is increasing. Kim mentioned this briefly, the supply chain issues and the price escalation continues to choke our industry. Labor is a big issue, which is a growing challenge. And something that I've started to see recently is also the design. And what I mean by design is the emphasis that the design is placing on sustainability. And what I mean by that is that there is a dramatic advances in construction technology, from artificial intelligence to drones, and in order to transform the processes and the performance, our industry is embracing this ever-changing environment. And those are the issues that I deal with and I assist my clients with in the theme that it would sit as it relates to our discussion for this afternoon.
Thanks so much, Sahil. We've got our first question here from George, and it's for Kimberly and Matt, and it sort of echoes off your comments on weather events. So the question is, are you or how are you addressing the risk of these weather events in your project planning and execution? So how does this show up in your contract and your contract administration? Mert, did you want to start, since you sort of had the weather events comment first?
I shouldn't have brought it up. And mine. Well, we're, of course, my firm and I, we're insurance brokers, so we're not designing construction contracts, but from an insurance perspective, like the types of issues we're seeing are related to everything from wildfires, but hurricanes, windstorm, and the big one is flooding. So these are covered. These things are covered, and because they're covered, it's really causing these claims are happening all over the world and are affecting the entire world, which affects what's known as reinsurance, which is the insurance of insurance all over the world. It's going to impact your project, whether you're rebuilding your home, in the suburbs, or whether you're designing a giant, shopping center. It affects the price because the reinsurers all over the world are getting decimated on claims. And I was literally just looking at some charts, and it's like 60s, 70s, 80s, 90s, and then just the claims just like shoot up like almost algorithmically in the last several years, and especially with big hurricanes. So it's covered, but it's driving risk and cost. And there's a whole science of risk management and risk engineering around preventing and mitigating damage to a building. And on our firm has a couple of specialists, and most of the other big brokerages have specialists and outside consultants that can help mitigate the damage to your particular project.
And I can add to that, Jordan, as well. And I think one of the key issues to address based on the question that has been asked is an issue of risk management. We don't have to manage the risk during the execution of the contract, but how do we think about and manage the risk as we are thinking about the project, as we are preparing the design, as we are thinking about sustainability, as we are keeping up with the requirements that have been placed on, depending on whether your project is a public project or a private project. So risk management is one of the most effective techniques. And what I also mean by that is a well thought out risk management program throughout the life cycle of the project has proven, at least projects that I've worked on and continue to work on, to identify potential issues ahead of time. Therefore, if you have identified the issue ahead of time, you're able to address potential schedule and cost implications, which as a whole is going to have an impact on your project and the claims down the road. And what I mean by that is the most effective dispute avoidance technique is your contract and specification review. You can do a risk management and then you undertake the contract and specifications review. The events from the last few years have, I'm sure, compelled both the owners and the contractors and everybody in the chain to re-examine their language in the areas of escalation and force majeure and others. And I think what this does is, with the projects having new requirements in the design phase, it addresses the concerns that we have faced, the industry has faced. This not only just affects the design, but I believe that it also strongly affects the contractor's requirements and how they approach their role on the project.
Yeah, I would agree with that. I think from the owner's perspective, it's our first kind of best step is looking at it and really forcing that conversation on the design side. Like, if this isn't getting better, it's obviously getting worse. We have to get ahead of it at the front end and not be so reliant on the insurance claims at the back end to help us get through the problems. Let's try to look at how we're avoiding them in the first place through our design steps.
And Kimberly, are you finding that on your end? One of the questions here is, how is that affecting price? Are you finding price escalation in your in the contracts because of these sort of considerations that are made at the front end?
Yeah, absolutely. Our conversation at the procurement stage has now become who's the best served from a project perspective to own the risk. So instead of just the owners paying at the front end, where does it make the most sense? Does it make the most sense for the trade to own the risk on the price escalation? Does it make the most sense for us to table some sort of sliding scale or industry gauge to define what that risk is, or the potential escalation is with respect to the front end risk, rather than just throwing money at it at the front end? Let's buy it at the right time and own it at the right level. So those conversations are becoming part of our tendering and procurement stages.
And Jordan, to add to Kim's point, and I think this goes back into the question that is originally raised, this one of design. This is a critical issue, and this points to the criticality of making sure that the design, when it goes out in the market and the design documents are developed appropriately for the type of the project, and that there's a clear understanding between the project participants of what is required in that contract. And I think that goes to the point that Kim just made in terms of the discussion that are now taking place at the procurement stage as to who is not only best suited for the risk, but is also best prepared to take on that risk. The unanticipated events that we have experienced in the last few years, I think the projects that have been successful and those that have been able to move ahead with less issues, or issues that have then resulted into resolutions, are the one where the team members are, number one, adaptable to the issues that they're encountering and are strategically prepared to deal with the challenges, keeping the best interest of the project in mind. And also, when a claim is being put forward, it is a claim with the right support, so that the owner, if the owner is receiving the claim on an issue, is not left in the dark or have to go out to hire a consultant to address the claim to only identify the deficiencies. This just causes more issues.
So we've had a lot of chat about sort of the challenges, I think, right at the outset, which is excellent, because I really want to focus on, here are the challenges we're seeing, and then we can move to how we're battling them and sort of how we can overcome them on sort of the back end of the presentation here. But before we move to the how we're going to battle these and some tactics to overcome, Kimberly, do you have any other challenges you're encountering, whether it be material scarcity, freight prices, port congestion? What are you sort of battling on a daily basis as it relates to sort of challenges in the supply chain?
All of the above. we've had a few projects, obviously, in the procurement and material supply stages, the well being the most prominent, and had some particular changes or challenges just given its sheer size and scale. We had 7 buildings coming online. There were 6 residential towers, 1 office tower, a multi-story campus-wide retail podium, a parking structure, all coming to market to be constructed in one phase. So we had a lot of impacts across the entire spectrum. So the construction industries, I would say, the heavily reliance on global supply chain makes it particularly sensitive to external effects. So to Mert's point earlier, the extreme weather globally, right? That's an impact, whereas normally we would just be looking at potentially, a regional implication. World events, whether it's pandemics or war, transportation to what you intimated there. Not only are we impacted by the usual oil price fluctuations, but the bottlenecks in the freighting were a project to manage in and of itself on the well. We were literally tracking shipping containers of glass across the ocean just to make sure we were able to confirm our schedule at the back end. So that's just not something that we're used to seeing on a project. It's, things we just take for granted. We had labor shortages through not only the typical trade union negotiations, but COVID-related impacts. We had testing facilities on the site just to keep the 900 plus workers safe through the pandemic. Materials that we typically bought off the shelf became long lead items, and our alternate material discussions revolved around what we had access to. Like I said, these are all things that we previously just took for granted and were a matter of course that now became part of our day-to-day conversation and how we were going to solve for them.
And Jordan, to Kim's point, I think this not only goes back to all the comments that Kim made in terms of the challenges which are encountered on the project. I believe these are the discussions that are going to become a normal. It's like having a big avoid sign on the road to say, please don't use this road. But now that we as an industry have faced these issues, are experiencing these issues now, the warning sign information is clear, at least from my perspective, that danger ahead due to, workforce shortages, inflation, recession, potentially, banking crisis. So these are now routine discussions, and, for contract drafters, I think this is such a crucial piece of time, not only for contract drafter, but also like folks that are in Mert's position that are insuring this risk. And how do you insure that risk? Can you even extend a policy under same terms if your project is delayed because of all these reasons? Mert, I welcome your input on all of this, because these are real challenges which are impacting the successful outcome of a project.
So, Sahil, you must have extrasensory perception, because that was just on my mind. In terms of the challenges, like the horror story that's in my mind that I've been chatting about with lots of people at Gowling is we've had several situations where a company, a developer, has started construction, and especially with COVID and all the delays and all the supply chain, things are dragging on. So they need an extension on their construction policy, because, as most people know, a construction insurance has a finite term. Could be many, many years, but it has a finite term. When it expires, there's no guarantee on what those terms and conditions are going to be. And we had a project where the initial started about 2018, I think it was, and the initial insurance premium for a major Toronto luxury name brand hotel and condo, the premium was, let's say, about $500,000. It expired recently, and it's still got many more months of construction to go. And we're looking at pricing of like $1.5 million to $2 million. That $500,000 was for 5 years. The $1.5 million or 2 million is for the next 1 year. I mean, that's like 20 times plus the rate. It's like abhorrent. There should be legislation to prevent insurance companies from doing that. There isn't. Luckily, we were able to find a much more reasonable solution. But the reason that the pricing happened like that was because a lot of the insurance companies that insured the project back in 2018, they're not in the business anymore. They're not doing construction insurance or property insurance out of Lloyd's in those particular syndicates. They lost so much money, they exited the business, so they're not around now to help us extend this policy. So it's be aware of that. Be aware. And I know we're now talking about challenges and we haven't gotten to solutions, so I won't talk about solutions.
So let's go to solutions. Go to solutions, Mert. I think that's where I want to go next. So
I'm scared.
I was going to set you up
myself.
Yeah. So go ahead. Let's talk about how we're going to overcome some of these challenges. And that's some of the questions I'm seeing in the chat too, is people really want to know, what's some practical advice? How are you battling these things? What are you doing on a daily basis? How are you making the project still successful?
Did you want
I see that there's a question, Jordan, from Olga in the chat, and her question is specific to the labor shortage issue. And I think this is an issue that is not a new issue. At least this is an issue that is now heading in the wrong direction in our industry, and this is an issue that needs to be tabled to be addressed to avoid not having the next generation or the generation that we have be part of our industry. And what some of the ways, Olga, that I have seen a few initiatives from my clients and the industry is education, educating the next generation of the opportunities that are available within the projects, within the sector as a whole, and expanding recruitment and developing career paths that addresses the needs and expectations of today's workforce, and also recognizing the importance of an inclusive workplace culture that resonates with a new generation of workers. But I welcome, Kim, how you are addressing the labor issue on your end.
Yeah, you're definitely reading my mind that time. We've been pushing the conversation with government for opportunities within Ontario's immigration strategy. Just what does that look like? Or what could it look like? The industry has what I think already an untapped resource simply through diversity in the labor front. Making the industry more approachable and more inclusive will go a long way in just helping our labor issues end to end. I feel like it's been somewhat of an untouchable or exclusive type environment that we need to make it more accommodating or more accepting, whether it's through a gender conversation or immigration policies, but just, opening those doors and being able to understand that we're not going to get through it unless we build that resource.
Absolutely. And so I think that's a good one on sort of how you guys are addressing the labor. But what about some of the other ones? How are you addressing and that's one of the main questions that I see being asked here is some of these different approaches to how we're addressing things, such as, and Mert, one's being asked to you about how you're addressing these insurance issues. What are you finding effective to overcome them, and sort of some strategies, some thoughts that you have on that?
Some of our clients have started purchasing large quantities of material, construction material in bulk, and storing it and warehousing it, especially if they have multiple projects going on. So we're starting to get into warehouse business, as crazy as it sounds, and that's kind of a hedge on inflation, but also guarantees a supply. At another sort of level, about risk management, Sahil and Kim were both talking about risk management at the design phase. One of the thoughts I just wanted to throw out there in terms of solutions is insurance, as everyone probably can acknowledge and laugh at, chuckle a bit. Insurance is usually the last thing on people's minds during anything at all, whether it's designing or building something new. But in terms of the risks and risk management, whether it's physical risk, like to a wind, is this exposed to windstorm, and all sorts of risks around a project, have that conversation early. Most developers and owners would have a conversation with Gowling early on in the project and start planning it and thinking about it and thinking about the risks and what could go wrong and how to mitigate it. So by including the insurance advisors, trusted insurance advisors early, it could be as simple as a couple of clicks on a button to say, this particular plot of land is really, really exposed to wildfire or earthquake or something like that. Maybe consider purchasing some land a few miles over here. It could be as simple as that, or it could be a much more engineering specific conversation about the design of a building or water damage risk mitigation. I would just encourage people to consider bringing insurance advisors in a little bit earlier as part of the team, as part of the whole team, to have a conversation about risk management.
And Jordan, to add to that, I think, one of the other things that we should not lose sight of is, one thing is certain based on the recent activities and the experiences that our industry has had, is that our industry will continue to change. And in order to successfully resolve the issues that are going to be experienced on a project, like moving forward, the project participants, not just the owner team, but the project participant team, need to adapt. And what I mean by that is they need to adapt with working with using new technologies while also embracing a spirit of compromise. If you have an issue on a project, find a way to address that issue. Not look, of course, if you're entitled to your position, be very sure in terms of your position and understanding and compliance with your position as it relates to the contractual obligations. Because you can spend a lot of time putting forth a position or defending a position when you should not be. Because if you don't understand your obligation correctly, you are not going to be able to have a discussion that allows for that spirit of compromise leading to a successful execution of the project.
But I see you're off mute. Did you have something you wanted to add about sort of how you're battling some of these challenges and what you found successful?
I don't know about successful, but it helped us get through it.
I call that a success.
We're always looking for ways to introduce more innovative methodologies and expanding our thinking beyond just the construction site, obviously. So one of the options we've been kind of dusting back off more recently is the option of prefabrication, and just how far can we take that? You look at the obvious solutions, but we're kind of expanding our reach now across the industry. So just kind of looking at how that could solve a few of these problems. We expanded our pre-purchasing options over the past few years. We were or are ordering mechanical, electrical equipment before even mobilizing on site sometimes. So this solution in particular has become a little more manageable recently as we learned specific supply chain backlogs or supply chain backlogs. But there's a point in time that supply chain or supply dates of every element within a building were unknown, and we had to guess which items were going to become showstoppers. We had pre-purchased and stocked all of our heat pumps for a residential building. When we knew that there was going to be a problem with delivery, but we missed the fact that there was going to be a back order on lock sets. So it's those, you can't buy all of the elements for a building and have it sitting in a warehouse. That's obviously not sustainable. So at the same time, we're looking at potentially, just that industry-wide realization that in order to navigate this new supply chain, how are we building that resilience on our design side and the procurement options?
And Jordan, one of the things to add to that very specific point is also your project delivery model and your project delivery method. The project delivery model and a method that may have worked like 3 or 4 years ago, it may not work in the circumstances and the issues which are now routine issues. Design is an issue that we have been speaking about, but certainly advancing, the contractor procurement early on in the process, reduces the impact on the items that we are speaking about. And it also enables a method that allows for a fast track and an early engagement from a contractor perspective, right? So thinking about the project model and the project delivery is crucial to large-scale infrastructure projects.
Yeah, I think, Seal, that goes to a question that was asked to you by an anonymous attendee, which deals with the, whether there's a consensus on what type of owner contract or admin GC arrangement is lending itself well to these sort of complex issues and how to address it. And I don't know if you can speak to whether there's a consensus, but what you're finding effective. And I think, Kimberly, they're sort of going through as well to, well, how does that work in the context of these really complex construction projects like you were dealing with at the well?
Well, and I think to Sahil's point, like bringing the contractors or the trades in early on, let's have that conversation about what we are going to have access to. What are the best solutions, either from a procurement or constructability perspective? We're doing that more so than ever now, like the design build type scenarios where we're bringing the trade in at the very early stages before we even have the design fully baked, and just how do we get not only the most cost effective solution, but how are we going to be able to deliver this, on time and ultimately on whatever the budget ends up being, right?
And Jordan, what I have also seen during the last couple of years is also whereby, to Kimberly's point, a contractor who's going to execute the contract is given a PO to assist with the design and have input, and also not only just have input but participate very thoroughly to make sure that they have input at the design phase, so that when the design is going to get executed, which they're going to be responsible for, they are fully aware not only what the design is, the material that needs to be required, so that if required, they can procure the material ahead of time to address these issues.
Yeah, and this is that, the collaborative approach that we're seeing more and more being utilized, I think, in the industry. And I think it's because it's proving effective, and so that everybody can, to some degree, or best as possible, be on the same page. So I think that's a great point, and certainly one of the new trends that I think we're seeing about how to overcome some of these challenges. So we've talked about sort of how we're battling the challenges and some strategies, but I also wanted to use sort of the last bit of time we have here to deal with what new trends. So we've talked a little bit about collaborative contracting. We've done a little bit about some sort of technology, but maybe we could talk a little bit about how we're diversifying sourcing, Are we thinking about liquidity on the projects, freight forwarding, different shipping ports? Maybe, I think Kimberly, you talked about better forecasting your demand, understanding when you're going to need things. So what sort of trends are we seeing and to help us overcome these challenges? So maybe, Mert, I'll pass it to you first, sort of in your insurance perspective. What sort of trends are you guys, and how is the insurance industry adapting to help overcome these challenges?
I think most of our clients and at the sort of CFO level are understanding that, especially when in our world of insurance, like the worst case scenario is an insurance policy expiring, and then either your costs are astronomical, or in some cases we have heard that some projects don't have insurance and they can't get a draw. The insurance is expired. So to avoid those kind of horrible situations, the trend we're seeing is baking in extra time and uncertainty as a contingency, and better forecasting in terms of the length of the project and building that in upfront, and having a very honest conversation upfront, because it does cost a little bit more to insure a project. Let's say it's going to be a multi-year project. You hope it'll be 5 years, but let's say maybe we buy a 6-year, maybe we insure this for 6 years, 6.5 years to hedge the downside at the end. It costs a little bit more because that premium is due, but you're hedging significantly the downside. So that is kind of one of the most important trends we're seeing among our clients and project owners and developers.
I would say from our perspective, as part of RioCan's ESG strategy, we've already been reviewing our material sourcing policies, looking at not only solving supply chain issues that we're currently discussing, but understanding, the forced labor components. Before being asked to join this panel, I had previously registered for Gowling's ESG reporting webinar. What was the title? Understanding Canada's mandatory supply chain reporting. So I'm going to have to catch the recording later, obviously, but it's those kinds of thought processes that we've got to look at it end to end, and bringing the people potentially at the back end of some of these conversations earlier in that discussion at, a true kind of partnership perspective, so that we're looking at a solution that is successful for everybody, from the trade level right up to the early design outset. Materials that were previously sourced from what have been heavily delayed or now unavailable global manufacturers, we've now shipped to potentially searching or sourcing regionally based materials, which may in turn create an even higher demand in those smaller markets, but we have to do the work to explore the options and understand the implications. And the best way to do that is to have those discussions real time with those providers, so that we understand the implication of adding that additional work to their pipeline and timing that appropriately.
Kimberly, the chat has exploded with a couple of questions, which I think is fantastic. So I want to ask you one first, Kimberly.
Did I hit a button?
No, you're good.
Please don't press the red button Kimberly to leave us.
Yeah. So the first one I have is a direct question for you, Kimberly, which is, have you guys thought about looking at vertical integration at all? So bringing anything in-house, and whether you can, whether it's that prefabrication, whether it's hiring trades or doing anything, more work yourself. Is that something that you've considered or you are utilizing?
Yeah, I'm not sure we're at the scale yet from a development or construction perspective that we would be bringing anything necessarily in-house within the REIT itself. We definitely look at those partnership opportunities through our CMs and our trades, again, to understand what those delivery models could look like and what potential solutions could look like. I would say at this point in time, we're looking at all options coming out of this current dip in the market. We're going to have some real problems in the industry, especially if we just go back to what we were doing previously. We're going to have to reposition ourselves for sure. Construction across the board.
That's very interesting, Kimberly. Jordan, the next question is from Dan Klitsky, who's asking about escalation claims from contractors and subcontractors in the fixed price contract mechanism, which puts the risk on the contractor, but the contractor is irrespectively under an assumption submits a claim that the owner is responsible. And I think we're facing this issue quite a bit, irrespective on whether you're on the contractor side or the owner side. And I think where we can do better as an industry, and perhaps more education, is understanding the crucial difference between risk management and claims mitigation. Because you can minimize the risk during the execution of the project, but at the same time, you also want to mitigate the claims that you're putting in. And I think being heavily focused on positive risks and opportunities to reduce the delay, the consequence, and the quantum on the claim side should be the thinking that the parties to the contract, with the best interest of the contract and the project at heart, should also understand.
Well, and I think that was like our earlier conversation about that risk management through the procurement process. Previously it was just give us our price. We want to know how much it is today, everything baked in. Now it becomes, okay, who is the best? What is the best way to manage this risk? And who is the best person or level within the contract to own that risk on the procurement or escalation side? So there's some very creative and interesting conversations that we're having with some of the trades, because the intent isn't obviously to have somebody stuck with this bill at the end of the day that they didn't expect. The intent is that we pay for what we order, and let's just make sure that we're being a little more responsible in when and how we procure the materials for any given project.
Yeah, and I think that goes to one of the questions about, how important do you think the existence of a strong and proactive consultant contract administrator on a project is? And I think this panel is going to say it's very important. So maybe Sahil, do you want to start with that, and everyone can echo your comments?
Well, you've taken the answer that I was what.
I know.
I would ask Sahil anyway, so you might as well just get the answer from him.
No, in all seriousness, I think it cannot be understated. The role of a contract administrator on a project that understands the obligations of the parties under the contract at the back of that individual's hand. Because a lot of the times, you have a contract administrator who is too afraid to call bad behavior. And if that individual is too afraid to call bad behavior at the time the behavior is starting, that behavior can escalate into a fireball that can have a massive impact on the project, which may lead to disagreements, parties not getting along, to the extent that parties don't even agree onto the meeting minutes as to what was discussed at the meeting, and they're fighting over the damn minutes. How are you going to be able to successfully, deliver the project in question? So it is very important. But Kim or Mert, what would you say?
It's a risk, right? It starts out as a risk, and it will become a claim, which is a point you drove home. And I think that's a very valid point about the importance here, which goes to, I think, a couple more questions that we've had about this. So we've clearly hit a bit of a hot button topic here. But I'm curious, one anonymous has asked us about, what do you think about a construction management contract, whether they have risk or not, involving the contractor early on in the process and putting more responsibility on the contractor, which I think kind of goes to this collaborative approach. And that notion, which will also, of course, go to the question, I think, that's also being asked at the same time, how do we do this? And how do you do this collaborative approach in a typical design bid build situation? How are we utilizing it? And how is that sort of shift happening?
It goes back to, Jordan, in my respectful view, the comment that Kim made, whether or not that contractor is the right contractor that can take the risk and should take the risk. Or is that risk taken on perhaps by the owner or somebody else? sure, I think it is very important, as Kim has mentioned and Mert has mentioned, to have a discussion that involves other parties and other entities that are going to have a role to play. But I don't think the risk should be given to a party just because. I think they need to understand the risk that they're taking on and be able to really understand the obligation that arises from that risk.
And
But
potentially mitigate it, right? So
yeah,
whether it be through their purchasing power or whatever the case may be at the supply end, if we're just talking about material supply. But yeah, that's why I think that conversation, being very purposeful and having it at the front end, is going to be important going forward, which previously we haven't really focused on that.
and just to also add to that, Jordan, I think it goes back to how do you yield great returns on an investment? And my view is that the project that successfully yield great result on an investment is the ones where you have implemented positive risk management to identify early on and exploit the opportunities that then leads to, a continuous performance improvement. So going back to the contract administrator or contract consultant role, it doesn't need to be done by the same party. And depending on the scope of the project and the project in question, an external third party can provide that risk management support. And that risk management support, it could be provided to the owner or the contractor, whoever is, again, best suited for it. Both parties may have their own risk management, depending on if you're dealing with a ginormous infrastructure project. But I think it goes back to how do you yield great results on your investment? And I think having implementation of positive risk management is important.
And I think that goes to the questions George asked here about, how do we balance the risk allocation strategy on construction projects? Where does the risk lie, and how, who's best able to take that on? And there's a number of strategies which you've talked about, Sahil, there. Kimberly, I'm curious if you have any other strategies about how you deal with risk allocation.
I think holistically, it's those early conversations. I've always said that we're not a business of a one and done type mentality. We all want to do this again. Nobody ever wants to walk away from a project and say that they never want to work together again. So the intent is, and obviously everybody's here to make money as well. So the intent is making sure that we're having some of those conversations early on, again, with the appropriate levels or the appropriate people in the room, so that we're understanding where the exposures are and getting ahead of them. And I think this supply chain disruption has given us, if nothing else, has really kind of forced us into having some of those conversations earlier on and understanding it at all levels, where, again, we kind of took it for granted before. Just, give me the price, tell me how much it's going to cost, and not really understanding the implications from everybody's perspectives.
And Jordan, to add to that also, you see this routinely on large scale infrastructure projects where there are consortiums with specific skill set and the risk that that particular entity is prepared to take on in order to form a consortium when they submit a bid. Those are the things that they are taking into account based on the understanding that they have from the project when it comes to market. The RFP that gets posted, the consortium is taking on that understanding, internal communications, several discussions, putting a response to the RFP together. Lots of those discussions are being taking place. I see, Jordan, that we have our warning to.
We have our 5-minute warning. So what I want to do with our 5-minute warning, and I really appreciate all the questions that are being asked, but what I think the last 5 minutes is, I'd love if you guys have any just sort of closing thoughts on sort of, the supply chain generally, or, about the discussion we've had today, or something you really want our audience to take away and think about and consider. So Seal, did you want to start with sort of your closing thoughts, and we can sort of just go around the panel on what everyone's sort of final takeaways are?
I think I want to leave our the folks who have joined us with basically 3 words, which is avoid, mitigate, and resolve. And what I mean by that is you can avoid the issue, and the way you can avoid is if you do a risk management. You can mitigate it by doing your claims mitigation, and resolve it as soon as it arrives, rather than parking it to the end. So those are my concluding 3 words, Jordan.
I think those are great 3 words, and I think those are ones to sort of remember on a project. And I think if you can do those three words, you're going to ultimately be largely successful in your delivery of the project. Mert, how about you for a takeaway message that you want everyone to sort of be thinking about?
One of the things that really hit me was something Kim said at the beginning, which is, these days of really tough supply chain problems and issues around the world are here to stay. This is probably not going to be a little blip that goes away soon. So this is part of the new reality that we have to live with. I'm going to throw a word in there. I really like Sahil's 3 words. The word I'm going to use is collaborate, but collaborate with all the stakeholders, and including your risk-related advisors by bringing us in early. We're just helping one of our clients. They're doing about $100 million reno to one of the offices around downtown Toronto, and we were involved early, talking to the general contractor, talking to the owner, talking to the couple of different general contractors who were bidding. So involved early, identifying risks and problems that could happen to the project. It helps avoid problems down the road. So my word is collaborate.
I love it. I think that's a great word too, and super important. Now, Kimberly, you're in the difficult position in that 4 great words have been taken. So what are your closing thoughts or remarks you'd like people to take away?
Yeah, I like all of them. I also do not have 3 or 1 word, but I would say that it's the same sort of sentiment, that early involvement, bringing in the project team, whether it's, not just the design or the consultant team, but definitely on the construction side, potentially some of the key trades, to start having some of those conversations and really kind of approaching it from a partnership perspective, as opposed to just this top down sort of mentality. And I think that's going to be the new way of how we're doing business in construction. We're not going to be able to see a way around it.
Yeah, and I think it's a proactive partnership. I can give you 2 words.
Good one,
might
Jordan.
be what you're doing. And I'm going to use 1 word because I want to say thank you to the panel. I really appreciate the conversation we had today. I think it was really fascinating from my perspective. I think our audience really enjoyed it. And I also want to thank the audience for, sitting through, participating, asking your questions. We did our absolute best to answer them. If you do have any other questions, feel free to reach out to myself, to Sahil, anyone else at Gowling's. We'd be happy to answer them. We can certainly loop in Mert and Kimberly as appropriate, and we'd be more than happy to do that. So thanks again for attending. With that, I'm going to send it off to Ted for the closing remarks. And again, thank you to the panel. And Ted, take it away, please.
That was fantastic. Thank you very much, Mert and Kimberly, Sahil and Jordan. I continue to learn more and something new about supply chain issues every time we have these conversations. It's such an evolving issue. And I really do share Kim's view that she said at the outset, that the changes that we've seen and the supply chain issues that arose right after the pandemic are not temporary. I think a lot of the changes that are coming as a result are quite permanent, and it's going to shake up our industry in ways that we're just starting to understand, and we'll reflect back on in many years to say, how different it is. Anything from the way we use technology, like a lot more Zoom meetings, to the way we draft contracts, to the way we plan and schedule and sequence our projects. So it's in a Confucius kind of way. These are interesting times, and it's fun to be a part of them in a lot of ways, but it is a lot of struggle, and we are here to help. We've assembled this panel because we think this is a critical issue for everybody to really start to try to get to their heads around, because it is complicated. They're big problems, and they take a lot of people and a lot of brain and a lot of thinking to work out, as well as a lot of collaboration, as we just heard. So that brings us to the end of our spring construction law forum. I want to thank our speakers. I want to also thank Margaret and Jennifer behind the scenes who put it all together, as well as the other organizers from Gowling WLG. We're always trying to improve. So we do have a survey. Jennifer, if you want to bring up the QR code so people can start snapping that. There's a survey. We'd ask you if you could fill it out. The effort here and what we're trying to get is information to you to help you in the best way that we can. You know best what you want to know, what you need to know, what gaps in your knowledge or what concerns you have. Let us know. Let us know how we did today. Let us know what you want to hear about in the future, and so that we can build our programs that service you guys as best we can. Gowling's is, as many of you know, one of the only few truly national full-service construction firms in the country. So we do service the entire country. We have offices in 4 provinces. But also lawyers called to the bar in many more, including up north. And so we do offer services and help both on the front end with contracts and structuring the projects, all the way through to disputes and resolution of conflict. And so we are available to help any way you can. You can also sign up for our newsletter if you haven't done so already. This is our spring construction law forum. There are many other events that we run throughout the year. We run occasional webinars. So if you are on our distribution list, you will find out about those. We heard a lot about adjudication today, which is now increasingly a national form of rapid dispute resolution. We run an annual adjudication workshop, usually in the fall, although with the pandemic, the timing has switched around a bit, but we're aiming for September or October for our next annual adjudication workshop, where we work through tips and trends in adjudication practice. So feel free to contact any of us if you have any questions, if you have any issues, if there was something you heard you didn't get a chance to ask, or it wasn't fully addressed after you thought about it, and we'll get right back to you on that. Finally, a reminder that in the fall, as I mentioned at the outset, we will have our fall construction law forum. And at that forum, we will be celebrating our 10-year anniversary of running these construction law forums. We're going to run it a little bit differently, certainly a little bit differently than we have in the last couple of years. It will be hybrid. If you can't get away from your desk, you're welcome to join us online. But we will also be doing it in person in many of our offices. Followed by a reception where we can get to know you a bit better and you can get to know us a bit better. So look out for notices for that. That'll probably be in late October or early November. We're just settling on the date. Which brings us to a close. So I hope everybody has a wonderful and cool summer, and we will see you in the fall. Bye now.